All right, thank you very much. Okay, so we've got a lot to cover, so let's get started. Let me just kind of give you a brief outline of what I'm going to walk you through today. So I'm going to do an introduction to intellectual property. We're going to talk about the types of intellectual property and break down what each one is and what type of protections each one provides and for what those protections are. We're going to talk about the value of intellectual property. And then we're going to talk about the vulnerabilities because there are a lot of vulnerabilities. And if you understand the value, then you really want to understand the vulnerabilities so that you can protect your intellectual property and it doesn't end up in the wrong hands or you don't end up losing your protections. Then we're going to talk about, excuse me, we're going to talk about how to protect your intellectual property and how to maintain your intellectual property. And for those of you that are excited, that have intellectual property, that are looking to create intellectual property or even acquire intellectual property, we're going to talk about where to start in order for you to uh, get set on the right path in the right direction. So that's what we'll be covering today. So without further delay, let's get into it and let's do our real quick introduction to intellectual property and its different components. So intellectual property refers to creations of the mind. That's where the word intellectual comes from. So they're creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images that are used in commerce. IP is protected by law, granting exclusive rights to creators and owners to use their creations and inventions and to prevent others from unauthorized use or reproduction. If IP laws exist to encourage innovation and creativity while enabling creators to commercially exploit and benefit from their work. So, what are the four types of intellectual property? We have patents, we have trademarks, we have copyrights, and we have trade secrets. I'm going to do a small dive in each one of these to give you a clearer understanding if you're not familiar with them. A patent is a legal right granted to inventors that gives them exclusive control over their inventions for a limited period, usually 15 to 20 years. It prevents others from making, using, or selling the invention without permission. So this actually is, you're actually creating a functional product of some sort, and the IP laws are protecting the patent, the invention itself. These are some examples of patents for you here. We got the alarm clock, we got the cell phone, we got the motorized scooter, and then we've got the drones or UAVs that are very popular these days. And sometimes you'll notice like the alarm clock is actually an interesting one because it's actually two IPs that have been put together to create a third IP. It's two patents. You got the clock that was patented, you got the radio that was patented, and then someone figured out how to make the clock trigger the radio to come on at a certain time of day. And that became a new patent. So not all patents are completely made out of original. If you can create an invention that takes a number of patents and creates a whole new function when they're combined together, you can also have a patent in that capacity. So that's the interesting thing with the clock radio or the alarm clock, if you want to call it. So, what about a trademark? Trademark, also known as a service mark, and the difference between a trademark is trademarks are for goods and service marks are obviously for services, is a recognizable sign, design, or expression that identifies products or services of a particular source from those of others. So this is the source that identifies who is the manufacturer or the entity behind the product itself. It protects brand names, logos, and slogans from being used by others in a way that could confuse consumers. So in other words, while the patent protects the product, the functional product itself, the trademark or service mark protect the name and the brand under which you sell. And these are some of the common trademarks that we all know and have seen, right? We've got McDonald's, Instagram, Nike, Apple. I don't even have to mention them. Most of these are embedded in our heads because they've done such a good job and spent billions of dollars marketing their brands and their names over the years. So this is what a trademark would look like. Then we have copyrights, and copyrights protect original works of authorship, such as books, music, and art. Copyright protection gives the creator exclusive right to reproduce, distribute, perform, display, or license their work. And these are some of the copyrightable materials amongst many, right? Music is copyrightable. Movies are copyrightable, books, magazines. So you can copyright these things to prevent people from plagiarizing, copying, distributing, making money off of creative works that you've come up with. So that's what copyrights are. And then there's trade secret, which is the most misunderstood out of all of them. A trade secret is confidential information that provides a competitive advantage to its owner. And that's key. It's got to provide a competitive advantage. It can include formulas, patterns, compilations, programs, devices, methods, techniques, or processes that are kept confidential and not generally known to others. So the key here is it's got to have a competitive advantage for you over your competition, and you got to do an excellent job of keeping it a secret, right? And let's take a look at what some examples of secret trade secrets look like. So we all know Coca-Cola's formula has been a secret since the 1800s. The Big Mac sauce, you may or may not know, has a trade secret formula. No one knows what that formula is. McDonald's keeps that a secret. WD-40, the recipe for Kentucky Fried Chicken. And then, of course, this one was a surprise to me, New York Times bestseller process. The New York Times bestseller process on how they elect their bestseller books and authors is a trade secret. No one knows that formula that they use to determine which books are going to be bestsellers. So I thought that one was very interesting. Okay, so now that you have some familiarity with the whole idea of intellectual property, I want to take 1 minute to play a game. So this game is called IP All Around Me. I want you to take a look at this image and identify as many pieces of intellectual property as you can in the next 60 seconds. Okay, go.
That's tricky, Roger.
All right. So that's your 60 seconds right there. You should have been able to identify a lot, but I'll go through this with you and let's see what you got, what you missed, right? So you should have all seen the trademarks: Disney, Coca-Cola, UFC. You've got trademarks. They're right in your face, right? If you look at it, pretty much every building has some type of trademark on it. You may have noticed that Coca-Cola is there, and while it doesn't scream trade secret, you should have known from the slide we saw previously that in and of itself, the Coca-Cola formula, the fact that Coca-Cola is there, we've got some trade secrets hidden behind these brands as well, right? We've got some of the things that are less obvious to see that we don't pick up right away, right? Because we're all busy looking at the signs and things, and we also have copyrights in those signs. The poster that you see, the Fox UFC, that poster's got copyrights in there, right? All of these designs, they have somebody created those designs and somebody owns the copyrights. But as we get lower into the street, we start seeing things that we take for granted, right? Let's start with these planters. Those planters on the left-hand side next to the police car, they have a design to them, which means somebody owns a patent on those, right? We don't think about those kind of things. How about these little white tubes that are sticking up in this dividing the street, right? There's a patent on those. Somebody owns a patent on those. Look inside the car, the steering wheel, somebody has a patent on it. The design of the car itself, somebody has a patent on it. And then if we get more into the nitty gritty, you look at the clothes that the people are wearing. Each one of those are fashion design. And a lot of those clothes that you're seeing are protected. They have design patents. They have all kinds of, they have brand names on them. So if you the point I'm trying to make with this picture is I love this picture because you're basically swimming in intellectual property, right? Pretty much everything around us is intellectual property. Even those stoplights, the one that makes them go from green to orange to red, from red to green, there's intellectual property technology that runs behind that. So our world is full of intellectual property. As I was telling Don earlier, we're talking to each other right now on intellectual property, right? We're using software that's somebody's intellectual property. So intellectual property is while often neglected, it's the one asset that's everywhere and all around us all the time. Every day we're using it. It's in the palm of our hands. It's under our feet. It's in our refrigerator. Everywhere you go, you've got somebody's intellectual property that's providing a service to you, right? That's providing a benefit of some sort to you. So big world, lots of intellectual property out there, and I hope now that I've programmed your brain that when you drive down the street, you're kind of just like, oh, that's intellectual property, and you're just having some fun. So with that said, where's the value in IP? Let's talk about that. So we obviously can easily tell there's monetary value. There's also recognition value in there and reputation value. There's legacy, which is one of my favorites. So let's take a look at these four core areas of the value of intellectual property. The right intellectual property, used the right way, can make the creator or owner very wealthy. And I want to identify the difference. Not, it's not that all the time the creator of the IP ends up being the owner, because sometimes IP is created as work for hire, which means that you, if you're the creator, you are relinquishing all of your rights to whoever you're working for. You're not going to get to keep any IP. So we get a lot of independent contractor creators that come in here to us and they say, hey, can you please review these contracts for us and let me know if there's anything negative? I'm like, well, you're a creator. You're going to be creating some stuff here that could be very valuable in the future. And these people are saying in their contract that any and all rights you have to the IP that you create under this work for hire agreement, you're going to give to them. And they're like, what? And they're surprised by that because they don't realize that they're going to retain no ownership. And who knows if they're going to create the next billion-dollar software, right? So if you're one who likes to hold on to your intellectual property, if you have it, you want to be very careful not to give it away by accident by signing some kind of work agreement, work for hire agreement with someone that's going to give you a job for 90 days and then let you go and then take all your IP. So I get this with software developers a lot. They come in here and I tell them, listen, never ever incorporate anything that you created on your own that you've been working on into an employer or into a work for hire situation, because if you implement your own proprietary pieces into their work, they're going to take it away from you. Or at a minimum, they're going to want you to give them a non-exclusive royalty-free license, which means they're going to make millions off of it and you're not going to get a penny off of it, right? So if you really care about your intellectual property, you want to be very careful on who you're assigning it to. So that's the difference. The creator is the person that actually comes up with it. And oftentimes creators are the owners, but in many cases, the creator gives up their rights and someone else becomes the owner and hence becomes very wealthy off the creation of someone else. IP can be monetized by the creator, the owner, or a licensee who's authorized to exploit the IP on behalf of the creator or the owner. And we'll talk a little more about licensees a little bit down the line. But a few examples of highly monetized IP brands include Louis Vuitton, Hello Kitty, Microsoft, Windows, Apple iOS, and Lipitor. We see these brands all around us. We see them on television, and they spend a lot of money and they do an excellent job on branding these. And these are multi-billion-dollar companies that have created all this, off of an IP. Hello Kitty was on the top 10 most profitable intellectual properties. And I was laughing about it with my daughter because she loves Hello Kitty. And it's just a simple character, but it makes billions and billions of dollars for the creators of that character. So value of IP, monetary value of IP can make you very successful, very wealthy. You just got to make sure you protect it, because when you have good IP, there are a lot of people who would love to get their hands on it and can cut you out of the deal if they can. So better be very careful with what you've created. And on that note, let's take a look at some people who made a lot of money off of their IP. You all know author J.K. Rowling, who created Harry Potter. Harry Potter has actually produced over $1 billion in royalties and franchise rights for Rowling on that. That's a lot of money. How about rapper Dr. Dre? He created the Beats headphones and ended up selling that technology to Apple for $3 billion. George Lucas, after all the money he made, he ended up selling the Star Wars enterprise to Disney for $4 billion. And then this is my favorite, the vacuum guy, right? James Dyson, with his vacuums, he has made over $15 billion. That's his net worth today. So IP speaks volume, and again, a lot of money to be made off the right IP. But let's get off the money topic a little bit and let's look at recognition. Intellectual property, when effectively branded and marketed, builds recognition that transcends borders. It's not just about protection, it's also about positioning. A recognizable brand earns trust, captures attention, and creates value. And global recognition turns IP into more than just an asset, it becomes a magnet for opportunity, driving demand, partnerships, and growth, all of which eventually become very lucrative for the owner. The more popular your IP becomes, the more recognized it becomes, the more people want to get involved and work with you, and the more money making opportunities you're going to have on the table for you. So there's a lot of recognition value. Again, if marketed, branded the right way, your IP can become very well recognized and it can make you a lot of money. Um, and then there is the reputational value of IP. So intellectual property, it's not just about ownership, it's also about the reputation of the creators and the owners. So when nurtured with quality, consistency, and integrity, it becomes a symbol of trust that defines how the world sees your brand. If we look at names like Rolex, Chanel, and Mercedes-Benz, they didn't just grow in value, but they earned reputations that command respect across all generations. A strong reputation turns IP into more than just a product, it becomes a standard for others to aspire by. How many people do you know that would love to have a Rolex on their hand, right? That either drive or would love to drive a Mercedes, what is their $300,000 the G, I think it's the G Wagon, right? How many people would love to? It's because these people created a brand that goes along with prestige. It speaks success. It speaks financial stability. So people want to be associated with these brands. So that's what these companies have been very successful in creating a reputation that has many aspiring after them. So then finally, like I said, my favorite is the legacy value of IP. When strategically developed and protected, intellectual property can evolve into a lasting family legacy. It's more than an asset, it's a name, a vision, and a story that's carried forward through generations. When we think of names like Ford, Kellogg's, Versace, and Campbell, these brands didn't just build businesses, they built legacies that survived their founders and continue to define industries. So, if you are one that values legacy and you want to pass your legacy on from generation to generation, and you've created your own IP that somehow has an impact on the world, that improves, that makes people happier, healthier, wealthier, whatever it is that your IP goes out there and you make a name for it, that legacy is going to far outlive you and probably your children and your grandchildren. It's got legacy written all over it. So that's the fourth value of intellectual property. Now that we kind of are getting an idea of what intellectual property can do for us, how it can make us wealthy, create recognition for us, really open doors of opportunities for us. We now have to look at the other spectrum, which are the vulnerabilities. How can we lose our rights? How can we lose our protections, right? So we are always thinking when we are accumulating assets, whether it be in 401ks or in cryptocurrency or gold and silver or real estate, we're always thinking, how do I protect these assets, right? But oftentimes, creatives they tend to overlook the intellectual property rights, right? So I am a lawyer. I have a business. I'm a business consultant. I have a consultancy firm. I have a law firm. And I have a real estate property. I have the basic assets, but I'm also an author. So I have a book that I've created that's going to far outlive me. It's going to be copyright will live 70 years beyond my death, right? So my children and my grandchildren are going to be receiving royalties from the books that I write. So that's value. That's something I want to protect. I don't want it to be stolen or taken away from my family, away from my legacy once I'm gone from this world, right? So I have to take those things into consideration. How do I protect my book and my rights in the books? I'm building an online academy, a business education based on my book. My book is the Six Pillars of Business Success, and we're building an academy that focuses on these six pillars, and that's intellectual property. Those videos that we're doing 550 videos. That's each one of those videos is going to be copywritten. It's going to be protected. It's going to have life beyond mine. How do I protect those? So we tend to overlook these kind of things, and it's probably because we don't always understand that our intellectual property, our creative work, is subject to certain threats. So let's take a look at what those look like. So, first vulnerability is infringement. Other people copying and stealing your ideas or pretending to be you. Theft, misappropriation is another. Counterfeiting or piracy is yet another. Loss of rights, you losing the rights because of something you did or didn't do. And then lawsuits that end up in judgments against our intellectual property that end up costing us our rights to those IPs that we've created, right? So let's start with infringement. Infringement of intellectual property is the unauthorized use of trademarks, service marks, brands, logos, and slogans to create, and this is key here, confusion in the marketplace about the source of the goods and services. For example, a few examples of infringement would be like knockoff Rolex watches or Nike shoes and clothing. They deal with this all the time. You know, you go to downtown Los Angeles and walk down the street for 5 minutes, somebody is going to sell you a Rolex for 20 bucks. And they're going to sell you the latest Nike shoes for $15, $20, right? Those are knockoffs. They're not the real thing. No one's going to sell you a $50,000 Rolex watch for $20. But it happens. There's a lot of infringement and theft in this world. So, infringement confuses consumers, damages a brand's reputation, and causes financial loss to the owner of the IP, right? Because you've got these cheap knockoffs out there of a prestige brand, and people are buying them. Some people thinking they're the real thing, and then they're leaving these negative reviews, or they have a negative outlook of the product when it falls apart because it's not the real thing. And now you've got damage to those brands. So infringement is a very big vulnerability in the world of IP. Then there's theft and misappropriation. Theft and surprisingly but true, often is at the hands of employees or contractors that you trust and bring in and expose them to your intellectual property, right? And this involves stealing someone else's intellectual property, and misappropriation is the unauthorized use or disclosure of intellectual property of others. Have you ever heard of corporate espionage? This is the process of corporations spying on each other, where they send people to work for each other. They send people as service providers into each other's businesses. And the intent behind that is they want to steal each other's trade secrets, right? And people go to, believe it or not, great lengths to steal intellectual property from each other. One example, a landmark case, was the 1969 DuPont case, which was the EI DuPont Nemers versus the company versus the Christopher case, which was a landmark case for misappropriation. And what happened in that case was DuPont was constructing a methanol production plant and developing a secret chemical process. And a competitor wanted to know what that process was, the formula. And so they hired these two investigators known as the Christophers. And the Christophers flew an airplane over this specific facility that DuPont owned that was not visible from ground level. And they started taking photographs from the air to try to get these trade secrets that were being put together inside this fortified compound, pretty much, right? So DuPont ended up suing them, and they ended up having the court rule in favor of DuPont and against these people because it was ruled that this was misappropriation. They were trying to use the airplane and the photography cameras from the air to take pictures of what this plant looked like and what formulas they were working on so that they can steal that intellectual property. Again, very common, a very serious problem when it comes to owning, managing, and protecting your intellectual property. Next one would be counterfeiting and piracy. Counterfeiting and piracy are the acts of copying, distributing, or using protected IP, such as music, movies, software, and luxury goods. Now, there's a lot of websites out there that a movie comes out. It's the first day of the movie, and suddenly you can go online at that website and watch the entire movie for free. How? Because they send somebody to the movies with a video camera that's recording the screen, and you're getting to watch the whole movie for free. Okay, that's going to be piracy. Counterfeits, of course, again, it's making knockoff products, fake purses, watches, jewelry, very big deal. And we all know these things, right? We know what piracy is, pirating music. We've had cases with websites distributing music, people sharing music without authority for free. We've got those are common things. One of the things we don't know about is another problem that falls kind of in within this realm is the idea of diversion. And diversion is a huge problem in our world. It's the process of unauthorized redirection of goods or services from their intended market to one that the owner has not authorized or is even aware of in many cases. Diversion is particularly big in the salon products and the pharmaceutical industries. What does that look like? So, when you have salon product shampoos, the high-end shampoos, their contracts with those salons are we only sell our products in salons. We do not sell our products in big box stores. We don't sell them in mom and pop shops. We are salon products. So we only sell in salons. But what happens is those salon products, they end up in the black market, and then the big box stores, they buy them through the black market, and suddenly you have salon products that are sitting on big box shelves that are not supposed to be on those shelves. They're not sold to them by the manufacturers of those salon products, right? Another same situation, pharmaceuticals get redirected and they're sold illegally on the streets and in places that they're not supposed to be. But the salon product situation was very interesting. When I first learned about this, I learned from an expert who was in the printing business for salon products. They printed the bottles for shampoos, things like that. And they did an event for us, and they kind of explained why the manufacturers of these products are very hard set on. Oops, sorry, didn't mean to do that. Very hard set on not allowing diversion of their products. It's because when they send these shampoos to the salons, the salons have a contract with them that say, hey, the shelf life of this shampoo is 6 months. After 6 months, the product is expired. It's not healthy anymore. So you need to get rid of the product. They're supposed to throw it away and not put it in the market. But a lot of salons, they're like, well, I paid a lot of money for these. And they have this guy walk in and say, hey, I will pay you $5 a bottle, hypothetically speaking, for your products that are expired. They're like, hey, $5 is better than throwing the products away. So they end up selling it to this guy for $5 a bottle, but that guy is going to turn around and sell it in the black market for $10 a bottle while the product is worth $40. The problem with that is when that product has expired, according to what we were taught is that those chemicals now become harmful for the users. They start breaking down and they start becoming harmful for whoever's putting that stuff on their hair or on their body to a point where they can even cause cancer from what we were told at this event. So if you really think about it, that's a serious problem. Not only are they damaging the brand or putting it in markets where it doesn't belong, damaging the pricing and all of that, but they're also putting the manufacturer of the product at risk because somebody buys a spoiled shampoo and ends up getting their scalp burned. they're going to sue who? They're going to sue the manufacturer of the product because they bought the product through black market where it's not supposed to be sold anymore. So that's where you have a big problem with diversion. Next vulnerability is loss of rights. While all these other things so far that I've explained to you are third party faults, normally loss of rights, majority of the time, is the fault of the owner or the creator of the IP. Loss of rights occurs when the intellectual property rights are lost due to an action or inaction of the owner. While there are different reasons for loss of rights for different types of IP, owner neglect is usually the most common cause. For example, trademark rights can be lost for failure of use, copyrights can be lost for failure to register, patent rights can be lost for failure to pay maintenance fees, and trade secrets can be lost for failure to protect, just to name a few. And I'll reiterate that trade secret part. You can't call something a trade secret and then go to lunch and leave it on your desk for all your employees to see. You cannot win in court if you claim something is trade secret and you are notoriously known for leaving it on your desk where your door is not locked, where anybody can access to it. Because if it was a secret, you wouldn't be leaving it on your desk. Trade secrets have to be protected as if though they are secrets. And that's why the Coca-Cola formula is in a vault to this day, right? They're truly keeping that a secret, and that's how trade secrets work. And then finally, the last vulnerability we'll talk about today is lawsuits. Lawsuits are very common in the IP world, and they're a very common reason for the loss of IP as well. Companies and people sue each other all the time, alleging many of the vulnerabilities discussed in this section. Another landmark case in this scenario is the Apple versus Samsung case in 2011 over patent infringement, which resulted in a $1 billion judgment against Samsung for allegedly infringing on Apple's patents. As an intellectual property creator, owner, or licensee, you can always be sued for infringement. You could be sued, and someone can claim that you are infringing on their mark. And how can that happen? Or on their intellectual property? Well, you create something or you create IP, you rush to market with it, you don't do your homework, you don't make sure that it's clear that it doesn't pre exist, that there isn't someone out there who already has the same or confusingly similar concept, and you end up putting yours in the market, and now you're infringing on someone else's IP, and you end up getting sued. But there's another problem that lawsuits bring forth, which is called invalidation. This is the process of going to court against someone who holds IP rights and asking the court to remove their IP protections, to invalidate their IP protections. One thing I see a lot of these in the trademark world. XYZ company goes and registers XYZ as a trademark, and they get the trademark. A year and a half, 2 years passes, and then XYZ in the East Coast that pre-existed them, it comes to their attention that somebody registered XYZ for the same or confusingly similar um, trademark or services as they're causing confusion. So now what the pre-existing company does is files a lawsuit to invalidate that trademark because they pre-existed the new trademark owner's time in the business and providing those services. And oftentimes it happens. The courts will rule in favor of the plaintiff and the trademark will get invalidated. And that's another thing that can happen in the IP world. And these are just a few examples. There's so much more that can go wrong. But again, this is why when it comes to IP, you always want to cross all your T's and dot all your I's because it's got a lot of value. And if you're going to be in the world of owning and exploiting for benefits the intellectual property that you've created, then you also have to be aware of all these things and you have to take the necessary measures to protect your IP from all of these things, right? My dad used to say it's hard to earn money, but it's even harder to keep everybody from taking it away from you once you've earned it, right? It's the same thing with IP. There are billions of IPs out there that don't make any money, but the right ones out there, that there are a lot of them that have made certain people very, very wealthy. If you've got the right one in your hand, you want to go to extreme measures to protect it and make sure that it's not stripped away from you because that's a life time of work for many of you. Okay. So on that note, let's jump right into what is I mean, how do we protect our intellectual property? And again, I'm going to give you a few steps. One, get legal representation. If you believe that your IP has value, get legal representation to make sure that you have a team helping you protect the IP. And we'll get into why in a minute on that. But make sure you got attorneys working for you. Register whatever IP you are allowed to register. Register your copyrights, register your trademarks, register your patents. Don't just sit on them. The only thing you can't register is trade secrets. There's no registration mechanism because obviously you don't want to register and make public your trade secrets. Your job is just to keep those secret and do a very good job of keeping them secret. Then there's contractual agreements. Whenever you work with your IP, make sure you have contractual agreements in place. Set internal safeguards, set external safeguards. And then ownership structure. How should you own IP to protect yourself? And then we'll get into those particular types of structures and setups and show you where you can put the ownership of your IP so that if you are sued personally, your IP doesn't become subject to those lawsuits. So let's get started. The world of intellectual property is vast with many facets, most of which are difficult to understand by the average creator. As you have seen from this presentation so far, IP owners must understand the values, vulnerabilities, risks, and benefits of owning intellectual property while working on developing, improving, exploiting, protecting, and maintaining their IP at the same time. And without the right people by your side, IP ownership can be daunting. As such, one of the best ways of protecting your IP is by having a having competent legal representation by an attorney with IP experience. Now, I want to hone in on competent and IP experience. I am shocked when I have people come here and they've got this great idea and they want to put a corporation together and they've got this great invention or great mark they've created, and I'm like, wonderful, let's do your corporation. Have you filed your trademark? Yes, my CPA is in the process of doing that. I'm like, CPAs are CPAs. They know tax law. They know how to save you money on your taxes at the end of the year. They are not intellectual property attorneys. They don't know the nuances and the intricacies of registering, protecting. Why would you go to a CPA to file your intellectual property? I won't even get into why the CPA is doing it in the first place, but please, if you're going to get legal representation, make sure it's somebody who's actually competent and also experienced with IP. And I'm not saying CPAs aren't competent. They are competent in their field, which is taxes, right? But lawyers need to be competent in this field, which is IP. So you want to find a competent attorney with IP experience. Next, register. Registration of your intellectual property is essential for protection. Registering your patent and or trademarks with the United States Patent and Trademark Office, also known as the USPTO, or your copyright with the United States Copyright Office is the best way to secure your intellectual property rights. Registration, if granted, will give you federal protections that you would otherwise not have. And for those of you who love the DIY concept, please be careful. You can do this yourself, but there's so many complexities in the application process that if you don't do it correctly, there are consequences. Please talk to an attorney first. Why? I have clients come in here that they filed their trademark themselves and they got a 2D refusal. A 2D refusal means that there is a pre-existing mark out there registered that is confusingly similar to the one that the uh, person that came to us, for example, is trying to register. And they did it all wrong. They describe when you file a trademark application, you have to describe your goods or services. And they've described their goods and services, and the trademark office said, no, these are the same goods and services as someone else. But then when we sit down and talk about the goods and services that this potential client actually provides, they really have nothing to do with the goods and services of the pre-existing mark. It's just that the potential client didn't know how to describe their goods and services, described them the wrong way, and that cost them the trademark. So now they have to start all over again, start that 1 year clock because it takes 12 months to get a trademark registered. They have to start all over again, that 1 year clock, and they're freaking out because they've already printed all the clothes or they've already printed all the pet products with the trademark on there, and now they've got a refusal, and everything has to be halted until we can fix the problem. So these are the reasons why, yes, DIY will save you 1,000, 1,500 upfront, but it will cost you a lot more down the line if you don't know how to properly file these registration applications. Okay, now let's talk about contractual agreements. Once you have properly registered your IP, all use, licensing, exploitation, and monetization should be done using well-drafted contractual agreements. These documents will ensure that your intellectual property is used in accordance with the terms and conditions that comply with applicable law, IP laws, and prevent your IP from being misused, infringed upon, invalidated, or tarnished, which is basically harm to your reputation. Contractual agreements address the when, where, how, and how long questions of IP exploitation. Specifically, this is going to be important if you're going to license your IP. If you're going to license your IP to a third party for them to sell it or distribute it or manufacture it or reproduce it for you, you better make sure that all the terms and conditions that are required and that you want are in writing and they've signed that. Because if you start allowing people to sell your IP without proper licensing agreements, that actually can end up invalidating your mark. You can actually end up losing your mark because if you get a trademark, for example, you are required to protect that and police that trademark, not just to give free licenses to anyone who wants to distribute it. That's not a trademark. You have to have the protections and those elements in place. So those are just some reasons why you want to have contractual agreements. Then you have internal safeguards. And internal safeguards are designed to protect against theft, misuse, and mismanagement of intellectual property from within. This is that example that I gave you about employees. Employee IP theft is huge. We deal with it all the time. And some of these measures that you can put in place include policies and procedures on how to use company IP, access control. If they don't need access to your IP, don't give them access to your IP. Employee training, monitoring and auditing your policies, procedures, controls, systems, making sure that they're all working. Data security, making sure that your IP data, amongst all other data, is secure. And then document management. Back to that example, don't be leaving your trade secret documents on your desk while you go to lunch while your door is wide open, right? It's not a matter of if, it's a matter of when will someone decide to take advantage and misuse or steal your intellectual property. How about external safeguards? External safeguards protect against threats outside of an organization. These include legal protections like registration, contractual agreements, as discussed earlier, monitoring and enforcement. When you monitoring means you're monitoring if anybody out there is misusing your IP, and there is ways to police those. Like we law firms have certain software that will put your trademark in, let's say, and we'll monitor it. And if it shows up online and it shows up in a manner that's not in line with what you've licensed, we'll notify you and we'll send cease and desist letters and go after those. So you want to monitor and enforce. And then finally, you want to put public notices. These little marks that you see, they each have meanings. The circle with the R is a federally registered trademark, while the TM is common law trademark, which means state trademark. And then the C is copyright. So trademarks and copyrights have symbols that you can put to let the world know that, hey, these are protected marks. Just a quick note on the TM. The TM only gives you protection in those states where you use your mark. The federally registered trademark gives you protection in all 50 states. So if you are planning to grow your business or you expand on your IP and it involves a trademark, you want to think about federal so you can protect it nationwide and not just in the particular states that you're currently in. Okay. And then lastly, in this section, protecting your IP, let's talk about ownership structure. Another significant method of protecting your IP is by creating an anonymous ownership structure. If somebody sues you, what are they going to come after? Your assets, correct? So if your IP is considered a part of your assets, then they are very much subject to a lawsuit and someone coming after your IP, especially if it has monetary value. So I always say, unless there's a reason why you can't hold the you must hold the IP in your personal name, put it in an anonymous, non-affiliated third-party entity that you yourself own, but do it in a way where you can go to a state that offers anonymity, for example, set up an entity there and have that entity be the owner of all your IP, register all the IP under that entity, and then turn around and license that IP to yourself and your organization that's going to exploit it from that entity and pay that entity a licensing fee, send the money there. So it's not your IP. And if you want to learn more about this, I would strongly recommend that you talk to Don and Kendall about that. That's an area that they focus on, helping you set up these entities with the anonymity and all that. They're great at that, very impressive stuff. So I would strongly recommend that you reach out to them and talk about, hey, I want to create an entity that's got anonymity. I want to set it all up. And then once you do that, if you want to come back to us, or if you have an IP attorney, go to them and say, hey, I want all my IP owned by this entity, and we'll take it from there. So great way to structure it. Another concept, another concern under this umbrella is if you own IP and you want to exploit and promote and sell that IP through an organization, but you have partners in it. If you created the IP and you own it, do not put the IP into the organization in which you have partners. Because if you have a falling out, they're going to try to keep that IP, especially if it's an IP that is lucrative for the organization, right? So you can end up losing your rights to the IP because that organization can take it away from you because you just brought it in without properly structuring everything. In reality, if you own IP and you want to be a part of an organization that's going to sell or promote that IP with partners, license the IP to the organization. Don't just transfer it to the organization because that's a trap. And if you value your IP, you don't want to do that. So these are all little things that you may not think about as an IP owner. I get people come here, they're crying because they created this wonderful software and they brought it into a partnership. The partnership downloaded the idea, took everything, and then kicked them out of the company. It's very sad to see that, but we can prevent those things and mitigate those risks if we invest to protect our IP. All right. Finally, maintaining your IP. What do you do to maintain your IP? Monitoring, renewing registrations, thorough documentation, continued use, and then, of course, I'm always going to advise you to retain IP counsel. So, the first step to maintaining your intellectual property is monitoring. This is a proactive process that ensures your IP assets remain protected, enforceable, and properly used. Monitoring includes tracking critical details such as registration and renewal deadlines for trademarks, patents, copyrights, and domain names to avoid accidental lapses in protection. Now, I want to spend, I know time's tight, but I'm going to spend a few minutes on domain names. When it comes to trademarks, one issue we run into is people have trademarks, but someone else has their .com. Huge issue. Why? Because at the time they were starting their business, they didn't think about buying the .com, which was available, and now somebody's cyber squatting it and has it up for sale for $25,000. Well, I always say, listen, if you think of a business and a concept, always buy the domain name first. It's a $20 investment, and if you end up not using it, who cares? You're out $20. It's much better than $20,000 to $25,000 to try to take it away from someone that's cyber squatting it. And even if you can take it away from them, you still have to go through the WIPO dispute process in order for you to get that domain name turned over to you, which costs you a minimum of $3,500 to $5,000. So domain names are also assets that are neglected if they correlate with our intellectual property, and you want to pick those up and put them away. For those of you out there who are authors, who are photographers, and you are the brand, you are the intellectual property, your first name, your last name, you're known, pick up the .com of your name. trademark your name because people will try to create knockoffs or create websites that pretend to be you, and all kinds of havoc will come out of that. So domain names are very important. So internally, monitoring involves overseeing how your IP is used within your organization to ensure it aligns with your policies and contractual obligations. Externally, monitoring means watching for potential infringement by third parties. This could be unauthorized use of your brand, copied content, or competing products that may violate your rights. Regular monitoring enables you to quickly identify and address violations, reducing the risk of dilution, misappropriation, or loss of rights. Effective IP monitoring is a foundational practice for preserving the value and integrity of your intellectual property portfolio. Okay, next, this is a big one. Renewing your intellectual property registration, as it does sound like a routine task, but it's the one that's surprisingly easy to overlook. Always treat renewal deadlines as critical legal dates. Set up calendar alerts, assign responsibility to a trusted team member, or engage legal counsel to monitor and manage your IP portfolio. This is a big business for us. Um, every IP piece that we've registered, every trademark we've registered, the clients always ask us to monitor it for them to make sure that when the deadline comes up. The problem with trademarks is you register your mark, it takes 1 year to get it. Once you get the trademark registration, you have 5 years where you don't have to pay any registration fees. 5 years later, you have to pay a registration fee. And then 5 years after that, you have to pay another registration fee. Long periods of time, easy to forget. Then it gets worse. After that second 5 year renewal term, it's every 10 years. So you may be around to renew your trademark 3 times, and then after that your heirs are probably going to be the ones that are going to need to remember. So if you're not properly calendaring and organizing these things, eventually it's easy to have an oversight, forget to renew your trademark or your registration of any kind, and then you're going to end up losing that IP, and that's going to be very costly for you. So keep that in mind. Wherever possible, submit renewal paperwork on the first day you become eligible. Don't wait until the deadline. And I'll use trademarks again as an example. When the trademark renewal window opens, it's 1 year long. You have 1 year to renew that trademark. And a lot of people wait till the last week. And then guess what? Something goes wrong, you forget, you get sick, you now lost that window, right? I always tell my clients, listen, the day it opens, the first day it opens, I don't care if I have a year. The first day it opens, I'm filing your trademark application, your renewal application for you, right? That's how we make sure that we have plenty of time to take care of business. Proactive action not only protects your rights, but also sends a clear message that your brand or invention is actively maintained and legally defended. People are going to think twice when they know that you go beyond measure to protect your intellectual property. Why are people afraid to infringe on Apple's or Microsoft's intellectual property? Because they will come after you like a pack of wolves to shut you down if you try to mess with their intellectual property, right? So people are afraid of messing with IP for those big companies. It happens because there are criminals all around the world that are not subject to American law, but we live in the United States, and when we properly defend our intellectual property, then people are going to think twice about infringing. All right. Then, thorough documentation. Third, thoroughly document everything about your intellectual property. This should include, but not be limited to, registration numbers and dates, renewal deadlines, names and information of licensees, if you have any, where and by whom is your IP being distributed or sold, and all other pertinent information. For my personal, I have about 18 trademarks of my own. I have some copyrights. I have a variety of intellectual property, and I have an Excel database, Excel spreadsheet database. It's got the registration, where it's registered, what the registration number is, when the renewal date is, what the registration date was. All of that information is there because if something happens to me, my son knows to pop that drive into a computer and he knows exactly where to pick up where I left off, right? It's very important, especially if legacy is important to you. All right. Continued use. This is something that most people aren't aware of. For certain types of intellectual property, most notably trademarks, continued use is not optional. It's a legal requirement. To maintain and renew your trademark registration, you must demonstrate that the mark is still actively being used in commerce in connection with the specific goods or services listed in your registration. If you fail to provide acceptable proof of continued use during the required renewal periods, your trademark may be canceled even if you still consider it a part of your brand. Happens all the time. If you cannot prove that you're continually using the mark, you are going to run into some challenges unless you have an excused non-use. There are very few exceptions under that category. All right. Lastly, and I'll continue saying this, certainly but not least, consider retaining experienced intellectual property counsel to help you navigate the complexities of IP ownership. Intellectual property law is nuanced and ever evolving with strict deadlines, specific filing requirements, and strategic considerations that can significantly impact the strength and value of your assets. An IP attorney can help you with everything from selecting and registering your IP to enforcing your rights, drafting licensing agreements, monitoring for infringement, and ensuring ongoing compliance with renewal and maintenance requirements. Having knowledgeable legal guidance not only reduces your risk of costly mistakes, but it also gives you peace of mind that your intellectual property is properly protected and strategically managed. All right, so now we're going to talk about where to start. And I've categorized the where to start into four different groups. If you own IP, if you want to create IP, if you want to buy or sell IP, and if you want to license IP. So we'll cover these one by one real quick, and then that will be the end of our presentation, and we'll take some questions from all of you. So if you already own intellectual property, start by getting organized. Know what you own, if, when, and how it's protected, when it was filed, when it needs to be renewed, and how it's going to be used or how it's being used. Keep your IP portfolio in order, or keeping your IP portfolio in order is the first step towards maximizing its value and preventing costly oversights. Retain the services of an experienced intellectual property attorney to help you organize, protect, and maintain your ownership right. That's where you want to start. Get organized, put it all together, and get yourself a good lawyer and start making sure that you have crossed all your T's and dotted all your I's. If you want to or are currently creating intellectual property, be smart and strategic. You want to start by determining if your IP is viable. Does it fill a market gap? Is there a need for it that's not being met? If there is, it means it has great monetary value. Consult with an IP attorney to determine if your IP can be protected and how. Not all IP can be protected. Okay? Trying to trademark the word apple for an apple cart is not protectable. That's a merely descriptive term. Trying to say Santa Clarita Valley's best lawyer is not protectable because it's a geographic term. So not every IP is protectable. Same goes with patents. Same goes with copyrights. You want to make sure that what you have is actually protectable. If you determine it is protectable, then when possible, pre-register your IP. The trademark office allows you to file something called an intent to use application. Okay, it's the same cost as a trademark application, but it's nothing more than a hold on that trademark until you're ready to use it. And it's a really good tool that you can actually pay a nominal fee to keep extending for a total of 3 years. They'll lock a name down for you for 3 years total while you actually put that name in use and convert it to a full-blown registered trademark. Patents as well. They have the provisional patents that give you temporary patent hold while you decide if you want to make the investment to fully carry out your patent into a fully issued patent. And then determine how to exploit your IP. Are you going to do it yourself? Are you going to have a licensee? These are all great conversations to have with an attorney to determine which direction you're going to take and which one is going to be the most beneficial and viable for you. All right. How about if you want to buy or sell IP? If you're not the creative type, but rather a master sales professional with a distribution pipeline, you may consider buying the creative works of others. Likewise, if you are the creative type with no sales skills at all, you may consider selling or licensing your intellectual property to a third party. However, Never do either one of these things without the guidance and counsel of an experienced intellectual property attorney. Lots of intricacies. You want to be very careful with that. So, the first step for you is to schedule a meeting with a qualified legal counsel who specializes in intellectual property transactions. Before entering into any deal involving the purchase or sale of IP, whether it's a trademark, patent, copyright, or trade secret, it's essential to understand the legal, financial, and strategic implications. An experienced attorney can help you evaluate the pros and cons of the transaction, such as the scope of rights being transferred, the value of IP, and any potential risks or liabilities. You do not want to go into any kind of buy sell deal with IP without really understanding what you're buying into. Because an IP that has ghosts in the closet, that has infringement issues, that's been sued, that's about to be sued, you buy something like that and you're going to end up buying that liability. You want to be very careful, right? And then you as a seller, you want to make sure that the buyer is legitimate, that if you care about legacy, that you want to pre-negotiate with them that they're going to carry on your legacy and they're not going to destroy your brand and run it into the ground. So all of these things are need to be taken into consideration. All right. And then if you don't want to buy or sell, then we get into the concept of licensing intellectual property. You don't necessarily have to own IP to legally exploit and profit from patents, trademarks, and copyrights. Likewise, if you own valuable IP, you don't have to exploit it yourself. The concept of licensing is the process of authorizing a third party called a licensee to exploit your IP, in which case you're the licensor, for you and pay you royalties in exchange. So if you're looking to license your intellectual property to a third party, start by talking to an attorney to ensure that you do it the right way. All right. Improperly licensing your IP can have serious consequences, including loss of your ownership rights. You want to make sure to properly document the terms and conditions of your licensing deal to enter into to mitigate the risks and reap the benefits. Similarly, if you want to be a licensee and obtain authority to exploit someone else's IP, you need to consult with an attorney to ensure that you're licensing a viable product that you can, in fact, exploit with little risk. All right. So, to summarize all this, in today's unpredictable and fast changing environment, intellectual property is one of your most valuable and most at risk assets. Whether you're an individual creator, rights holder, or licensee, understanding the fundamentals of IP, recognizing its value, identifying vulnerabilities, and taking steps to protect and maintain your rights is essential. With informed and proactive management, you can preserve the integrity of your IP and maximize its long-term potential. So I hope you found this valuable and you learned something today. And with that said, I am all ears for your questions.
Okay, Roger, thank you so much. I appreciate it very much. I just put in the chat that link for a free consultation with you and your team. I love that. So, guys, honestly, as you can tell, there's a lot of things that I never considered. Probably you as well. A lot of you on the call tonight have never considered that really you have to protect. And that's a big part of an asset protection plan and strategy is protecting the IP. And so Roger's so generous on this. To get an hour of an attorney's time, especially someone like Roger, who's very, very busy, it's very, very valuable. So Roger, I know that's a pretty high value offer, and it's just hard to get an hour of someone's time at the caliber of Roger. So we really do suggest, I put that in the chat. It's clickable. Go to protectwealth.com. Let's talk IP. / let's talk IP. Click on that, schedule a call, and Roger. So when someone does that, when they click on that link and you'll be sent their information. What's the next steps for someone who does want to talk to you?
Yeah, absolutely. Within 48 hours, you'll get an email from our office to schedule a time for us to get on a call. If you are local, which I'm sure many of you are not, but if you are, we can meet in person. If not, we can schedule a Teams or a Zoom call and we can give you that 1 hour, kind of hear out what you've got planned, what you're trying to accomplish, and give you some guidance as to where is going to be the best place for you to start. If you, again, like the four categories, if you're interested in licensing, if you're interested interested in starting to create IP. And I always encourage clients to start creating IP or gain access and add IP to their assets. So if you need guidance on how to do that, we can put you in in the right direction. If you are more of a, hey, let me buy some IP. Are there people out there selling IP? We can look into those things. So we can help you with all of that and guide you. But within 48 hours, someone will reach out to you, we'll make an appointment, and we'll make sure that you get some valuable information that you can really utilize to your benefit when it comes to IP and you getting involved in the world of IP and protecting your assets.
That's great. Thank you so much. Really generous offer. I know we went back and forth about different things, and you were just super generous and said, "Hey, this, let's just give them an hour consult." And we do sincerely appreciate that because your time is very valuable. So thank you so much. Super excited about that. So definitely, everyone suggest you sign up. And as far as questions goes, we don't have a lot of questions right now. But the thing is, I personally thought about a lot of things, especially in the software. You know, today's world, gosh, if it isn't online, if it isn't somewhere with AI or created somewhere somehow, there are so many things that I think a lot of us don't think about. So is I guess you deal with a lot of things. Is that one of the main things we deal with now? Is a lot of online businesses now, if they create something and it's proprietary, that's something they should talk to you about, right?
Definitely. If you are building anything that's proprietary, you definitely want to consult with an attorney. You can utilize the free hour that we're giving you to talk to us about that to make sure that you're protecting yourself. Because usually mistakes start happening early on, and exposure to what should be protected starts happening early on, and people start stealing pieces of that. So we really wanna make sure that you are covered and you've crossed all your T's, dotted all your I's before you start. It's always smart to start before you put the IP out there. A lot of people have already created something and they're pitching it, and they don't have an NDA. They don't have any kind of documents that the people they're pitching to are signing to protect themselves. So, very important to make sure that you've got the proper documents and protections in place so that you don't have regrets down the line.
Fascinating. Yeah, and I think anyone who's starting a business, running a business, you need to be thinking strategically this way. Like Roger mentioned, he's talked to a lot of people who've come to him in tears over something they didn't do. And this is why, we here at Protect Wealth Academy, we really focus on asset protection. And this is a massive part of an asset protection strategy, and especially business owners. And, and over the years, Roger, I'm sure you've talked to a lot of people, even in real estate, doesn't matter if it doesn't necessarily have to be tech, but there's things like you showed the picture. Anything you can make proprietary, I guess you can pretty much trademark or patent or protect it, right?
Absolutely. If you're creating something that is marketable, you
Mm.
want to try to protect it. And that's important, especially if you know what you're creating is filling a gap in the market that others are not. That is where breakthroughs happen. That is where billion-dollar projects. I mean, if we look at Ring, right? I mean, look at the doorbell, the camera doorbell, Ring. It was turned down by many investors. And then look at it today. How many doors do you see without a ring on there, right? It became a huge product. It filled a need that others didn't see that the creators did. So if you're working on something that you feel is going to fill the need, fill this gap that no one is catering to right now, you want to make sure you go the extra mile to protect that.
It's just fascinating to me. It gets my wheels turning. I've got a lot of family members who even got patents and different things. Come from some engineers in my family, and that's kind of the things they do. They deal with this stuff all the time, and
Mhm.
so it really is. A lot of people work years and years and years. You even mentioned in that picture, like I was thinking, like even like down to, and I've heard this before, right? The type of rocks and the proprietary strategy to make the asphalt, right? And
Mhm.
the combination of chemicals to make that stick together in the road. It's taken thousands of hours for people to come up with how to do that. And so, people work hours and hours and we just take it for granted. But no, it's there's a lot of things out there you don't think about. And if you're running a business, doesn't matter what it is, you've got to protect it.
Absolutely. Absolutely. It is I think you have to have the asset mind when it comes to IP. You got to start realizing that your IP is an asset and that you need to protect it just like everything else.
Roger,
Fascinating.
I was going to stay hidden and stay in the background, but I need to make a little comment here. I've seen so many of our students ignore the importance of intellectual property. And in fact, some of you, if you know my background, know that I started with Jay Mitten, the father of asset protection, who in 2007 sold a company for $500,000, and he sold it, and the new people hired a manager to come in and run it for him, who created his own company, moved all the intellectual property into his own name, and he's called legally his, or whatever he named it, and none of it was his. And so,
Yeah.
but after a 3-year battle in the legal world, it wasn't worth going after anymore. It's just it, what what a horrible way to do it. I know that a lot of students have written books, and so I've had a lot of people ask me over the years about the books that we wrote. So we wrote that book years ago, and it
Hmm.
sold 500,000 copies, but we don't put it in Protect Wealth. We assign it to somebody else. Somebody
Mm-hmm.
else owns the intellectual property, who licenses it to Protect Wealth Academy, who has an indemnity agreement that says, if we say something wrong, and it's been licensed to several people, whatever marketer, I don't care what you're gonna say about it. Well, I do care, but you're liable for that. I'll just be responsible for what happens in the book. Is that pretty much how you handle it? You mentioned that you never keep intellectual property in an operating company. Is that pretty much what you do?
Uh, well, yeah, I mean look, it's a case by case situation, right? So sometimes one method makes sense for a particular client and the way they're structured, and another method makes sense for a different type of client. We don't try to use a one size fits all approach in our processes. We do it more client centric. It really depends on where the client is, what they're trying to accomplish. But yes, it's always for me personally, I look at it this way. I look at how litigious you are as a person and how litigious your business is. How subject to legal liabilities and lawsuits is your business? How subject to lawsuits are you? If I determine that you are highly subject to lawsuits or your business is, I would try to separate your IP into a completely different entity. My model is have another entity own the IP and then either license it to you or license it yet to another third party. But I wouldn't want to put it into any kind of entity that has exposure, any kind of entity that has a negative exposure to it that could end up sinking the ship of all your IP because they got sued for something completely unaffiliated with your IP, if that makes sense, right? So for me, it's a case by case situation when I'm talking to clients to determine which method I'm going to suggest to them for protection.
And Don, you talk about that in our asset protection summit too. You'll cover safe assets versus unsafe assets and where to put them.
But what Roger specializes then in is not only the 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 copyrights, the trademarks, but the contracts, and
Hmm.
how critical that is, that we have the right licensing agreements, that we've got the right employment contract. Talk to me a little bit about those contracts and the importance of those, would you, Roger?
Yeah, absolutely. So, when it comes, if you are a creative employee, if you are being hired to create intellectual property, oftentimes the person or entity hiring you is going to want all the rights to what you create. They're going to want you to sign a work for hire agreement that legally allows them to take the rights from you if that document is properly determined. So they're going to want you to sign that. If you're a creative who doesn't want to do that, then you want to be very careful on signing work for hire agreements. You want to have an attorney review that agreement. You also want to be very careful if you have your own pre-existing intellectual property that you use. Software is very unique. Software can have an engine that's written in code that is used to build other software, right? So if you own the underlying engine, and you decide to bring it into your work for hire agreement so that you can build their software, which needs your engine, you now trap your engine in that document, and you're going to have to give it to them royalty free. You're going to have a lot of problems. I always say, don't ever bring any of your IP into the work for hire agreement ever. Just create it from scratch for them. If they want to use your engine, negotiate a separate licensing deal with them for royalties in advance, because once you're in the trap, you're in the trap, if that makes sense. So
Wow.
you want to be very careful when you come into these. If you are a third party developer or software, and you're being hired as an independent contractor under a work for hire agreement, or even as an employee, you want to be very careful if you don't want to give your rights away. And you always want to let them know that if you have pre-existing IP, and ask them specifically to exclude any and all rights to your pre-existing intellectual property. So that's very important. And
Great.
I don't know if you see it, gentlemen, but there's a couple of questions whenever
Yeah,
you can answer
let's
those.
jump on them if that's okay. So we
Yeah.
have anonymous attendee. That's a good French name. We like that one. That's French. It's French, okay? I, okay, I have already patented software related to healthcare. Any thoughts on the best way to search for a venture capitalist to help me grow a startup? That's a great question.
Very good question. And yes, my advice is go out there and attend trade shows and events that allow you to, when you get a chance, if because they're very expensive if you're going to display. If your software is patented, protected, and displayable, rent booths and start putting your software on display at events. There are a lot of events that for the healthcare industry, for the software industry right now, it's very big, and if you attend those, a lot of the potential investors are there, so you might be able to meet some people. There are a couple of organizations out there. I don't know where you're based out of, Anonymous, but I know in California, in Orange County area, we have an organization called Octane. And Octane, what they do is they raise seed money for pharmaceutical companies, software companies, and software, pharmaceutical, and health companies, which kind of is exactly what you do. You might want to look them up. They're in Orange County, California, and they're called Octane. And that's what they do. They raise seed money. You might want to get involved with organizations like that. I know sometime in June or July, they always put a big event on here in California that draws a lot of people. So you might want to research those kind of things. If you can get involved with organizations like that, and you have something impressive, you might find the assistance you need there. So I hope that
Very
helps.
cool. That's
Great.
exciting. Good for you. That's awesome. Good luck on that. Ricardo, I want to file a provisional patent to protect right away, then hire an attorney thoroughly for final patent. Any advice? So they've included things that they're working on. Any advice on that? It sounds like they need to reach out to you, Roger.
Yeah, you're more than welcome to reach out to me, and I will put you. I don't do patents. My expertise are copyrights and trademarks. I have a colleague that does patents, and he's actually used to work for the USPTO. He's got a lot of background in that. He was a patent examiner for the USPTO, very experienced. I'd be glad to put you together with him if you'd like to reach out to us. And then we'll go ahead and connect you with him. He's out here in California, but he can definitely assist you because patent law is federal, so we can work with you anywhere in the United States.
And sometimes there's other things that Roger, I think, along with the patent, at least I know this going through that process myself in the past. There's things you also need to talk to Roger about that go along with that big time for sure. It's not just patenting, it's everything else with the IP.
That is correct. So you want to make sure that you talk to someone experienced in that, and then take their guidance and then build upon that. That's very important. So yeah, go ahead.
Okay, Ann's asking, what's the expected investment for hiring a law firm to protect IP, developing, researching, maintaining IP trademarks and patents? That's probably tricky. Depends on so many factors, right?
100%. Absolutely. So, yeah, it's going to depend on how big your IP portfolio is, if you, and what's in it. Is it all trademarks? Is it copyrights? Is it patents? Right? Copyrights are dealt with. at a different office than trademarks and patents are, and depending on the number, how many years have you been in it? So these are all important questions. Usually, that's why we offer this 1 hour consultation, is to analyze what you hold, what your portfolio looks like, and then come up with a plan on making sure that a maintenance plan to make sure that everything is properly documented, and calendared, and done. So it really is going to depend on the volume of intellectual property that we're working with.
Ooh, that's great. And then Ann's asking a follow-up question, or a great question. I think that a lot of entrepreneurs should definitely think about. It's kind of a chicken or egg question. Should writers of white papers or books protect their work before sending to publishers or self-publishing?
My advice is always yes, because once you put intellectual property out there unprotected, then you take the risk. And in that industry, in the entertainment industry, in the publishing industry, things, there are a lot of shady things that happen. So you take that risk. So my advice is always protect. It's not that expensive to copyright a book. It's not that expensive to do copyrights. Patents, they can get very expensive. Trademarks, they're up there. They're not as expensive as patents, but they're up there. But copyrights, they're not that expensive at all. It's not worth taking the risk to save $500 or $600. That's you can copyright a book with an attorney for $500 or $600.
Yeah,
So
guys, and this is
Roger,
why it's important.
let me
Go ahead.
ask you a question.
Mhm.
So if I publish a book, I send the manuscript, isn't there a non-disclosure agreement? Or should somebody review that for me before I send in the manuscript?
Well, the question of isn't there a non-disclosure agreement is, if it depends on if they gave you one or you gave them one and they signed it, right? Oftentimes you can't get the big established players to sign those things. They don't want to take the risk because you're submitting something and they may have seen something similar and they don't want to get sued. It really depends on how cooperative they are on the other side. Um, signing non-disclosures, things of that sort for a book, I don't know. I would still feel safer if it's protected before sending it out, unless you know that a particular publisher you want to work with won't work with you if you've already copywritten the book to yourself. Usually they can always do an assignment, but that's going to be a case by case. It's a question that needs to be asked, right? So a publisher may have a particular rule that they will not publish books that are copywritten to the author already, whatever it may be. So it's a case by case, but it really depends on the kind of people you're dealing with and how much you trust them, and if they're willing to sign paperwork to protect you.
Great,
Fascinating.
great
Yeah.
answer.
Fascinating. And this is a big stumbling block for a lot of entrepreneurs starting out. They're not sure where to go first. And so it's a great resource here, Roger, to have you. Thank you again for that free consultation. Again, that's in the chat. In the chat, guys, click on that link if you want to have a consultation with Roger and his team. Definitely recommend you do that, especially if you're a business owner. Again, Don and I talk about this all the time. Asset protection. This is asset protection. This absolutely is protecting those assets that could be worth, in many cases, far more than your real estate holdings, without a doubt. So,
Absolutely. Absolutely.
thank you so much, Roger. We appreciate your time tonight. It looks like we're right on time here to wrap it up. If there's any more questions, we definitely recommend you reach out to Roger and his team with that link. Anything else before we close, Roger?
Thank you very much for having me. I really enjoyed it. I hope you all learned something, and I really appreciate your time.
Thank you again for your time, Roger. It was fascinating. We really do appreciate it. Everybody else, we look forward to seeing you guys again on a future webinar. Thank you for your time tonight.